A very good day to Professor Mohamed. This is our group's projectual presentation. I'm Lakshmiya Sivakumar, the group leader, and my group members are Intan Nur Shahira, Amisha Kargil, Farah Ainan, Mohana Gayatri, and Vishnu Darshan. I'll now pass the floor to the first presenter.
Thank you, Lakshana. Assalamualaikum, Prof. I'm Farah Ainan Hashmi Razmi. I will be presenting on question 1, and my part is issue 1, the first two laws and application. So the first issue is whether the contract is frustrated. The first law is Section 57, Clause 2 of the Contracts Act 1950. The section states that a contract to do an act which, after the contract is made, becomes impossible or by reason of some event which the promisor could not prevent, becomes void when the act becomes impossible or unlawful. So applying Section 57, Clause 2 of the Contracts Act 1950 to the situation, since Hotel Thistledown was going to be used for the preparation period for the general elections by the government of Malaysia, it became impossible for the hotel to carry out the contract with the company. This is because the hotel would be fully booked for the purpose of the elections. So by virtue of the section, a contract that becomes impossible and could not be prevented is void. Therefore, since it was impossible for the hotel to honor their contract with the company, the contract is void, consistent with Section 57, Clause 2 of the Contracts Act 1950. Now, moving on to the second law, it is the case of Goh Yu Chew and another, and Soh Kian Tee, 1970. So the case is mainly about the appellants which agreed to construct two buildings on land belonging to the respondent. The respondent then paid $5,000 to the appellant, but then the encroachment of the neighbor's house into the land, it was so resulting in to be impossible to construct the buildings according to the plans. So the respondent claimed the return of the $5,000. The trial judge discovered that in the circumstances, it was impossible ab initio to perform the contract and held that the respondent was entitled to the balance of deposit after deduction of all the expenses incurred by the appellants. The federal court affirmed the trial judge's decision. So, by applying the case above to the situation, the facts in the situation between the company and Hotel Thistledown and the said case are pretty similar. So, it was impossible for the hotel to carry out the agreement with the company, as the government of Malaysia had chosen their hotel to use for the preparation of the elections. Since the facts between these cases are similar, the outcome should be similar as well, and the contract between the company and the hotel would be void and frustrated. That is all from me. Thank you.
Good day to you, sir. My name is Amisha Kaur, and I will now present on the remaining content for issue 1. In the case of Standard Chartered Bank and Kuala Lumpur Landmark Sdn Berhad in 1991, the plaintiff loaned 20 million to a third party and the defendant company charged some lands to the plaintiff to secure repayment of the loan. The third party defaulted in the payment of the loan, so the plaintiff commenced legal proceedings and applied for order for sale of the defendant's land. The plaintiff then entered into a redemption agreement with the defendant whereby it was agreed that the defendant should pay 2 million to the plaintiff and deliver a bank guarantee providing for the payment of 18 million to the plaintiff. The plaintiff then suspended the legal proceedings and the defendant paid the 2 million. Subsequently, the plaintiff and defendant were served with an injunction obtained by Monsia Investment Private Limited, restraining them from proceeding with, completing, or in any manner whatsoever acting upon the redemption agreement. Hence, the defendant could not comply with the redemption agreement and pay 18 million to the plaintiff. The plaintiff then revived and pursued their claim for foreclosure of the charged lands in court. The plaintiff submitted that the injunctive order restraining the parties from acting upon the redemption agreement had frustrated the performance of the agreement. The court held that the redemption agreement had been rendered impossible to be performed because of the injunction obtained by Monsia Private Limited. The very essence of the redemption agreement had been frustrated as its performance would be a radical change of its original terms and conditions. It can be seen in the case of Standard Chartered Bank and Kuala Lumpur Landmark Sdn Berhad. The court held that the redemption agreement had been rendered impossible to be carried out and therefore the very essence of the redemption agreement had been frustrated. This can be applied in the situation of the company and Hotel Thistledown as the facts are again similar. The very essence of their contract was for the hotel to provide the spaces booked by the company to the company. However, this became impossible as the government of Malaysia had decided to hold their general elections there as well. Since the very reason for their contract had become impossible, it can be said that the contract had been frustrated. Next, Another case that can be referred to is the case of Ramli bin Zakaria and others and Government of Malaysia in 1982. Here, the appellants were a group of 86 vocational school teachers who were successful in their application for the teacher training. One of the conditions of the offer which was accepted by them would be upon completion of the course, he be accepted as teachers on the UTS scale. By the time they completed their course training, the UTS scale had been abolished and the Abdul Aziz scheme came into force. This was applicable to the salaries of the applicants. The applicants claimed that they should have been paid under the UTS scheme. Respondent pleaded that as the recruitment of teachers into the UTS had been discontinued and the offer to employ them under the UTS had become frustrated, upon appeal to the federal court, it was held that where a contract has been entered into, there is a change of circumstances, but the circumstances do not render a fundamental or radical change in the application originally undertaken to make the contract something radically different from what that was originally undertaken, then the contract does not become impossible and it is not discharged by frustration. The court also held that in this case it is wrong to say that the contract was not applicable, was not capable of being formed, and it was not therefore frustrated. Now, the facts of the case of Ramli bin Zakaria and others and Government of Malaysia can be distinguished with the facts between the company and Hotel Thistledown. In Ramli bin Zakaria and others and Government of Malaysia, the agreement was not impossible to be carried out. This is unlike the agreement made between the company and the hotel. Therefore, they should be distinguished and bring about a differing outcome. Since the agreement between Hotel Thistledown and the company was indeed impossible to be carried out, the contract is likely to be said frustrated. In conclusion, for the first issue, it is likely that the contract between the company and Hotel Thistledown is frustrated on the grounds that the agreement had become impossible to be carried out. That is all from me. Thank you very much. I will now pass the floor to my fellow groupmate.
A very good day to Professor Mohammed. I'm Lakshina and I'll be presenting on the second issue. The second issue is whether the company is entitled for compensation. The first law is Section 66 of the Contracts Act 1950, which states that when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. By applying Section 66 to the situation faced by the company, as the contract made is found to be void due to frustration, Hotel Thistledown is bound to restore the payment made for the reservations. The second law is the case of Public Finance Berhad and Ewan bin Saring. In this case, the respondent and the appellant had entered into a hire purchase agreement of a motor car. During the course of the hiring, the vehicle was seized by the Customs and Excise Department for an alleged offence and was then forfeited. The court held that when the agreement was entered into, the appellant had represented that they were the owners of the said vehicle and capable of giving good title to the respondent. But the agreement became void pursuant to Section 57, subsection 2 of the Contract Act, when the vehicle was seized and forfeited, so it became impossible for the appellant to assign and make over all its right, benefit, and interest in the said vehicle. Thus, the appellant must return the money they have received from the respondent who had paid 57,000 ringgit to purchase the car, in accordance with Section 66 of the Contracts Act. By applying this case, similar to the case of Public Finance Berhad, the hotel had refused to go forward with the reservation. The contract became void pursuant to Section 57, subsection 2 of the Contracts Act, when the reservation was cancelled. Similar to this case, when the appellant must return the money they have received from the respondent who had paid an amount of money in accordance with Section 66, Hotel Thistledown must do the same by making a refund for the losses suffered by Olive Essentials and Berhad by virtue of Section 66 of the Contracts Act. The third law is the case of Lee Seng Hock and Fatima binti Zain. In this case, the respondent had entered into a sale and purchase agreement with the appellant to sell the deceased's half share of the land at a purchase price of 40,000 ringgit. The appellant had paid to the respondent a sum of 4,000 ringgit, which was 10% of the purchase price. Later, a Qadi certificate was issued distributing half share of the land to the respondent and Baitul Mal in the proportion of half share each, where the respondent and Baitul Mal had a quarter share each in the land. However, later the government had acquired the whole land and awarded compensation to the appellant for his half share and the respondent for a quarter share of the land. The appellant then filed an application claiming for compensation due to the respondent, less the balance of the purchase price under the agreement. The respondent contended that the agreement had been frustrated because of the compulsory acquisition of the land by the government, so it became impossible to perform the agreement. The trial judge upheld this contention and ordered that the compensation payable to the respondent for a quarter share of the land be paid out to her less the sum of 4,000 ringgit. The appellant appealed. The court, however, dismissed the appeal and held that the acquisition of the land had radically changed the obligation of the respondent to sell her half share of the land to the appellant. The compulsory acquisition of the land had frustrated the agreement, which discharged both parties of their obligations under the agreement. The court held that since the agreement was void, the appellant cannot claim any right to compensation, but at most was entitled to be refunded the 10% deposit he had paid to the respondent. By applying this case to the situation of Olive Essentials Sdn Bhd and Hotels of Sedang, as the contract is frustrated, it is void. However, to relate to the situation, even though there is no compulsory acquisition involved here, the obligations of both parties shall be discharged, similar to the obligations of the appellant and respondent being discharged due to the frustrated agreement in Lee Sung-Hok's case. Similar to the appellant in that case being entitled to the refund of 10% of his deposit, Olive Essentials Sdn Bhd is also entitled to the refund of all the full payment remitted for the reservations that are cancelled. To conclude the second issue, the contract is frustrated, resulting in it being void, and the company, Olive Essentials Sdn Bhd, is entitled for compensation of all losses suffered by virtue of Section 66 of the Contracts Act 1950. That's all from me. I'll now pass the floor to the next member.
Good day, sir. My name is Vishnu Darshan, and now I'll be presenting about the discharge by breach under the common law. Next slide, please. According to the common law, a contract is breached when a party fails to perform his contractual obligations, while every breach of contract will be give the innocent party a right to claim damages from the defaulting party for any loss or damages suffered by him. Serious breaches will enable the innocent party to not only claim damages but also to be discharged from all obligations. Under the common law, there are two situations which gives the innocent party the right to be discharged from the contract. First one being a repudiation and second one being the fundamental breach. Repudiation means when one of the parties indicates through words or conduct that he does not intend to fulfill his commitment when it becomes due in the future. Repudiation of contract is also known as anticipatory breach. Repudiatory breach is a breach which is sufficiently serious to entitle the innocent party to bring the contract to an end. However, it is quite difficult to identify if the repudiatory breaches occur or not. Serious difficulties can arise if care is not taken. The innocent party usually has two options. It can either accept the repudiation and treat the contract as at an end or affirm the contract and insist on performance. It can be difficult to decide whether a breach is sufficiently serious, whether there is neither an outright refusal to perform in the future, nor a breach of condition, but where the innocent party considers the breach or threatened by breach to have significant commercial consequences. This act can be expressed through an unqualified statement to that effect as seen in Hochster and Delatour. In this case, a courier was engaged on April to accompany the defendant on a tour commencing in June. 3 weeks before the commencement date, the defendant wrote to the plaintiff that he had changed his mind and the plaintiff's services were not required anymore. The plaintiff commenced action immediately as the defendant objected on the ground that there could be no breach of contract before June. And the court held that the plaintiff was entitled to do so, although the time for performance was not yet due. The defendant's written statement clearly amounted to repudiation. Repudiation can also be implied from the conduct of the defaulting party that a person has no intention to carry on with the contract. In the case of Lovelock and Franklin, in which Dell agreed to sell a piece of land to Lovelock at a certain price provided the price was paid over 7 years due. But Dell sold the land to another person, and it was held that by Dell's conduct, he had impliedly repudiated his agreement with Lovelock. Next is fundamental breach. Fundamental breach is so severe or significant that it allows an innocent party to terminate the contract and treat himself as a discharge in addition to bringing the damages action. There are two conditions which has to be satisfied for it to be a fundamental breach. The first one is to look at the importance attached by the parties to the term which has been broken, whether it's a condition or warranty. And the second one being to examine the consequences of breach of the term which innominate or intermediate terms. A fundamental breach of contract is generally known to occur when a previously agreed upon contract is cancelled entirely due to another party's actions or inactions in some cases. While with most breaches of contract, the termination and could be considered a breach of contract, that is not the case with fundamental breach and therefore does not provide both parties the right to take legal recourse due to the serious nature and legal implications of the fundamental breach of contract. Thank you. That's all from me.
Good day, sir. My name is Mohana Gayatri Ramesh, and I'll be discussing on the case of Chu Yin Lu against S.K. Viswalingam Pillai. So basically, the facts of the case is the plaintiff had agreed to do a certain work on the defendant's land by providing the laborers. In return, the defendant had to pay 70% of the value of the work done for every 2 weeks. However, the defendant refused to pay the money after the work was done. So the issue here is whether the defendant had breached the fundamental term of the contract, and the court held that the refusal of the defendant to continue the payments for every 2 weeks, which is equivalent to 70% of the value of work done, was a fundamental breach of the contract. Thus, the plaintiff can rescind the contract. So the application would be fundamental breach of contract amounted to repudiation of contract by the plaintiff. So it is said that, in a nutshell, when the root of the contract was breached by the defendant, the plaintiff is entitled to rescind the contract. But when it comes to this case in Chu Yin Lu against Viswalingam Pillai, the court opined that, according to Section 40 of Malaysia Contracts Act 1950, only means to enact what was the law in England and held, where a party to a contract refuses altogether to perform or is disabled when performing his part of it, the other side has a right to rescind it. So in this case, the High Court held that the defendant's refusal to make fortnightly payments, which is the 70% payment to the plaintiff for building works as a breach, was a breach of an essential term. Similarly, in Hua Chia Lin against Malin Jaya, this case was held in Malacca. Back in 1996, the High Court held that in Malaysia, the terminology of fundamental breach, which was a concept of the common law, thought not exact terms, has become a creature of statute. The relevant provision, which is now enshrined in Section 40 of the Act, therefore, in order to invoke Section 40 to rescind a contract, the term has been breached must be a fundamental term such as condition or innominate term that goes to the root of the contract. If the breach of a term is only a warranty, the promisee cannot rescind the contract, but he's entitled to sue for damages, just like my fellow mate said earlier. That's all from me. I shall pass to the next presenter.
Thank you, Mona. I'm Intan Noshaira. I'm going to discuss about discharge by breach in Malaysia position. So, Section 40 of the Contract Act stated that when a party to a contract has refused to perform or disable himself from performing his promise in entire, the promisee may put an end to the contract unless he hits 75 by words or conduct his conscience in the continuance. Next. So the general principles of discharge by breach of contract generally was outlined by Gopal Sriram in Vijaya Times Square and M concept of Sundarian Berhad case. It is for the court to determine who is the innocent party and who is the guilty party. When a party commits a breach, he repudiates the contract. The innocent party then could either accept repudiation by terminating the agreement or can ignore the breach by treating the contract as alive and sustaining. So the question is whether the innocent party is entitled to terminate the contract for breach and claim under Section 40 of the Contract Act, and whether the innocent party can rescind the contract ab initio and claim for restitutions. Next. So under the Section 40 of the Contract Act, the innocent party may rescind or may put an end to the contract in two situations. The first one is the defaulting party refused to perform, and the second one is the defaulting party is disabled himself from performing his promise in its entirety. So the breach gives the innocent party an option to rescind or terminate or to affirm or continue the contract. So the section of the Contract Act 1950 actually embodies the contract from the common law position. We can see in the case of Chu Yin Lu and S.K. Viswalingam Pillai. The court interpret refusal to perform and disabled to perform from the repudiation and fundamental breach in the common law. So similar to the case of Hua Chia Lin and another in Malim Jaya, in this case, the High Court held that this amounted to the fundamental breach on the part of the defendant, which entitled the plaintiff to rescind the contract as the building was delivered was not what had been upon agreed. So, since the earlier case of discharge by breach in Malaysia, which is the case of Chu Yin Lu, there are more Malaysia case follow the reputations and fundamental breach concept in the common law. For instance, we can see in the case of Wu Pu Oi and Gertrude Guo and another, the court held that the defendant were in the breach of contract and liable for damages to the plaintiff. So the refusal of the plaintiff to pay for the extra could not be regarded as showing an intention to not longer be bound by the contract. So the defendant were not justified in repudiating the contract when the plaintiff refused to pay for the extra. So another case we can see in the case of Chin Yik Development Sdn Bhd and Setapak Hut Development Sdn Bhd. So in this case, it's the concept of the fundamental breach is explained. Whereas the term breach is fundamental to the contract, the innocent party entitled to treat himself as a discharge from further obligation under it. And where the terms breach is only subsidiary or minor in nature, the innocent party may not treat himself as a discharge under the contract, but may recover damage for the non-performance of the subsidiary. We can see in the case of Rasia Munusami and Lin Tan and Sons and Sdn Bhd. In this case, the judge explained the concept of repudiations. It is not a mere refusals or omission from one of the contracting party to do something which he ought to do that will justify the other in repudiating the contract, but there must be an absolute refusal to perform his part of the contract. So really for discharge by breach of contract, in section 40 of contract 9, in section 40 of the Contract Act 1950, the phrase put an end to the contract, it means that the contract is voidable at the option of promisee, which is the innocent party. So the innocent party is released from further performance of the contract which remains unperformed, and innocent party not bound to accept or pay for any further performance of the contract by the contract breaker and entitled to compensations of any damages for not fulfillment of the contract as stated in section 76 of the Contract 1950. So an innocent party must restitute, which is that is pay back any advantage or benefit he has received according to the section 65 of the Contract 1950. So, however, Section 40 of the Contract Act can be read together with the Section 34 sub 1 of the Specific Relief Act in 1950. Further performance of the contract is terminates under Section 40 of the Contract Act, or if the contract is declared rescinded under Section 34 sub 1 of the Specific Relief, entitled to get compensation for any damages under Section 76 of the Contract Act, or reasonable compensation as justice may require under Section 37 of the Specific Relief Act. That's all from me. Thank you.
We would now end the presentation. Thank you, everyone.